on bail. Three words that's outraging a lot of people after that bond was significantly reduced for the suspect in that deadly stabbing at a high school track meet in Texas. Karmelo Anthony is charged with fatally stabbing 17-year-old Austin Metcalf in the chest on April 2nd. On Monday, a judge reduced Karmelo Anthony's bond from $1 million to $250,000. The judge says her decision to lower the bond was based on several factors, like his age, his ties to the community, and no prior criminal history. He will remain on house arrest until his trial. Police say Anthony allegedly admitted to stabbing Metcalf as he was taken into custody, but claimed it was self-defense. According to reports, Austin died in his twin brother's arms. He was laid to rest on Saturday. Joining me now for more on this track meet tragedy, federal defense attorney, author of Truth and Persuasion in the Digital Revolution, and host of the Wall podcast, Ron Chapman. Ron, we appreciate you joining us and taking the time this morning. What's your reaction to the bond being reduced for Anthony to $250,000 after it was originally set at $1 million? Because we asked our viewers about 6 days ago on a social media post, should it be set at $1 million and not lowered? Should he be out of jail for what he allegedly did? Everyone across the board said no.
Interesting. I love that idea, asking the public and getting the feedback, because that tells us where everybody is. But no doubt this is a tragic case, and usually the public wants punishment at this phase. But that's not what we traditionally do in court. We have to presume that somebody's innocent until a jury determines that they're guilty. That's a very important thing. Everybody certainly would want the same thing. So what does the judge consider? Danger to the community and the ability to appear at trial. We have a young man who's claiming self-defense. We have Texas, which is a stand-your-ground state, which is a law that is going to be very favorable to the defense in this case. And when it comes to the facts of the case, we see that there's this altercation in a tent, and it just appeared to get wildly out of hand with the defendant allegedly pulling a knife and a death resulting. Certainly very tragic. But with the bond decision, the judge has a very difficult thing to do and determine, is there any future danger to the community? And in a case like this, where you have a young man who hasn't done anything like this before, and there are restrictions like keeping him at home, which I believe is a restriction, you end up with a decision that cuts a little bit closer to what we would normally see in other courts. $250,000 is a lot of money. Nobody's going to be harmed with him at home. I think the judge made a good call here. And while some people may be upset about that, we have to remember we do not punish at this phase. We presume innocence and we protect the community.
Okay, Ron, so I'm going to push back on that. You said she made a good call. He's not a danger to society. He took a knife to a track meet. He pulled it out, according to the witness that told the police officers, took it out and stabbed him. I guess I'm trying to figure out, that's not a danger to society. If he's out and about and someone sets him off again, he's not willing to just do that again, because according to the witness, it wasn't even a major scuffle. Immediately, that witness told police, this is what we do know, that immediately it was sort of a touching, a back and forth. All of a sudden, the knife came out, boom, stabbed. That one young man is dead. He admitted he did it. So I guess I'm trying to figure out what's going through the judge's mind on this.
Yes, absolutely. And I don't think anybody is going to excuse the conduct there if it did occur. But remember, we have to start with the presumption of innocence. We can say, though, he did admit to the conduct. He claimed that it was in self-defense. But I think here the restrictions that the judge is going to put on him would be considered reasonable in preventing any sort of future danger. I believe he's under house arrest, and there are very limited movements that he can make in the community, which should prevent any future harm like that. We traditionally would see a tether in this case. And again, remember, we have an amount of money that has been posted for bond. Usually a percentage of that $250,000 has to be paid. Family members are going to be making sure that he is not moving about the community and he is remaining inside of his residence. And I don't believe we're going to see any dangerous conduct from this gentleman moving forward in the future with these sorts of restrictions. And it's a difficult call for a judge to make with the presumption of innocence. But I think that the judge is hearing the facts and doing their best. There's one other thing I have to mention here, and that is The tempered statements of the prosecutor in the press conference immediately after the bond. We usually from prosecutors hear this is egregious conduct, the defendant is on trial, we're disappointed with the decision, but what we heard instead was we need to let all the facts play out. We're still investigating this. These are very tempered statements to come from a prosecutor's mouth, and I think there may be a little bit more to this evidence than we know.
10 seconds or less, Ron, if you can, 10 seconds or less. How do you defend the young man bringing a knife to a track meet?
Yes, I mean, it's the decision to bring the knife in the first place, very problematic. But when it comes to the actual altercation, from what I understand, we have a stand your ground law, and we have the victim who approached the defendant in this case. That is going to be very favorable for the defense when we look at the instructions, but the jury gets to make their mind up.
We'll see if it works. Ron Chapman, always a pleasure having you on. We appreciate it. Fanchon?
Thank you so much.